Welcome to everyone, and thank you for being here. My name is Gerald Newman, and I'm the director of the Human Rights Program here at Harvard Law School. And we are here just to discuss the question of children who grew up under the governance of the Islamic State in Syria and their current fates. This is a problem that was brought forcibly to the attention of readers in the United States earlier this year, when sudden headlines pointed them to prisons in Syria where Islamic State fighters had taken over and were holding young boys as human shields and hostages. And one could ask, what were these young boys doing in the prison? This is the unsolved problem of Islamic State families. There have been debates over the repatriation of women and girls who traveled from Western countries to join the caliphate, and children who were brought there or who were born there. Western countries have been slow to bring them home. This panel addresses this aspect of the problem in the wake of a recent decision of the United Nations Committee on the Rights of the Child, finding that France had violated its obligations toward children of French nationality in Syria. The Convention on the Rights of the Child is the most ratified human rights treaty in the world. Every UN member state except the United States is a party to that convention. We have today an extraordinary panel to discuss these issues. In the order in which they're going to be speaking, let me introduce first Professor Benyam Mesmour, who is professor of law at the University of the Western Cape in Cape Town, South Africa, and is currently the Eleanor Roosevelt Fellow here at the Harvard Law School Human Rights Program. And he is a member of the UN Committee on the Rights of the Child and is currently speaking from Geneva, where that committee is meeting. Fionnuala Ní Oláin is, among other things, the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, the University Regents Professor at the University of Minnesota, and the Director of the Human Rights Center at the University of Minnesota Law School. Nazma Dirzadeh is the founding director of the Harvard Law School Program on International Law and Armed Conflict, and professor of practice at Harvard Law School. And Patrick Wey is a celebrated historian and sociologist who teaches at the University of Paris 1, Panthéon-Sorbonne, and is a regular visiting professor at Yale Law School. This event is organized by the Harvard Law School Human Rights Program, but is co-sponsored by the HLS Program on International Law and Armed Conflict, the HLS Program on Law and Society in the Muslim World, the HLS Institute for Global Law and Politics, and the Dullah Omar Institute for Constitutional Law, Governance, and Human Rights at the University of the Western Cape. Can I call attention to two Zoom facts? One is there's a Q&A function at the bottom. We will have time for Q&A after the panel has spoken. And please submit questions that I will try to ask as many of as I can through the Q&A function. And secondly, that a message will be appearing in the chat, which will help you to subscribe to the newsletter of the Human Rights Program if you are so interested. So without more, let me turn it over to our first speaker, Professor Mesmour.
Thank you very much for the opportunity, but also for the generous introduction. Let me start with two disclaimers and a disclosure. The disclaimer is that I'm not speaking on behalf of the Committee on the Rights of the Child, even though, as mentioned, I'm a member. And the second is we unfortunately do not have an official English version of the case that I'm going to talk on. So we have to rely on for those of us who don't speak French, we have to rely on an online translation. The disclosure is I had the privilege to serve along with my colleague Anne Skelton as a case rapporteur on this case. And I wanted to throw that at the outset. Now, let me say a couple of preliminary points in relation to the optional protocol on a communications procedure. It's a very important one. We call it the third optional protocol because there is also the optional protocol on children in armed conflict and the optional protocol on sale, child prostitution, and pornography. And it currently enjoys 48 state parties. In fact, even though the ratification is slanted towards specific parts of the world, a good number being from South America and Europe, there are an increasing number of countries that are coming on board. So it's a very important procedure. And the number of cases has been increasing, not just in terms of numbers, but also the diversity of the nature of the cases that are coming. For instance, on non-reforma, on female genital mutilation, or on climate change. And of course, we have this case that we call the French repatriation case. Even though there are a number of different names that you can find in the media that they refer to it, the foreign terrorist fighters case, or the repatriation of French fighters and their families case, and so forth, so forth. Now, one writer, Professor Helen Duffy, she has described the context of these cases, the French repatriation cases, as being, and I quote, morally disturbing and politically toxic. It's probably difficult to argue that this characterization is actually off mark. Maybe two words that I would be tempted to add is the one that says legally complex, because the cases actually raise complex legal issues. The cases were brought by individuals acting on behalf of their grandchildren, niece, nephew. In fact, except for one of them, who's a national of Algeria and residing in France, all the authors are actually French nationals. The children that are involved in the case are actually French nationals. And their relatives, the mothers, fathers, and so forth of these children, are alleged to have collaborated with Daesh, ISIL. And while there are some reflections that myself, but also my co-panelists might be able to offer in relation to the importance of nationality and so forth, nationality was not significantly challenged in this particular case. The French government didn't contend that these are not French citizens, even though nationality, of course, for the purpose of establishing extraterritoriality and so forth, becomes an important aspect. Now, central to the contention is that, first of all, these are children. Most of them are actually young children. Some of them were actually born in France. The others were born in Syria. They are being held in Roj, Ain Issa, Hol camps in Rojava, which are under the control of the Kurdish forces. This is important because the Kurdish forces are non-state actors, but of course they're exercising some control in that jurisdiction. The allegation was basically that the authors claim that the government of France, in this case, even though we know for a fact that there are close to 50 countries who have nationals in these camps, in this case, the government of France has not taken the measures necessary to repatriate these children to France, and that this failure to repatriate constitutes a violation of a number of provisions of the Convention on the Rights of the Child. At the initial stage of the case, the provisions that were invoked were Article 2 on non-discrimination, 6 on the right to life, survival, and development, 3 on best interest of the child, 20 and 24 on parental responsibility and the right to the highest attainable standard of health, and of course 37 on cruel, inhuman, degrading treatment in relation to the Convention on the Rights of the Child. In fact, at the early stages of these circumstances, the government of France had displayed some positive gestures towards these families. In fact, the chief of staff of President of France, Emmanuel Macron, had replied to the authors as regards to the French minors, both in Iraq, but also in the Syrian Arab Republic, that they would actually be getting some support for repatriation. In early 2018, the president himself actually gave assurances that the situation of those children would be dealt with on a case-by-case basis, especially if criminal responsibility is ruled out by local authorities. But of course, subsequently in 2019, this is one of the main important turn of events, the president's chief of staff actually wrote to the families and said to them that they're not going to grant grant permission for the repatriation of these children that are actually represented by the authors. As a committee, as the Committee on the Rights of the Child, the first port of call is to actually deal with the question of admissibility. Now, in relation to admissibility, exhaustion of local remedies is important. Have they exhausted in this particular case? There wasn't really significant contention that the domestic remedies were unavailable and they're ineffective. We're looking at a situation where the children and their parents are in Syria, and the possibility for exhaustion was not really contested by the government of France either. Now, there were few children that were repatriated back into France as the case was developing. So we also felt that there was no need to deal with admissibility in relation to those specific children who've been repatriated. Consent was one of the contentious issues, whether or not the children's parents have given consent and so forth. And the committee felt that based on the evidence that has been produced to it, in relation to the fact that the grandparents have been in constant touch with the mothers, and in the fact that this case would actually be relevant for protecting the best interest of these children, and because of the limitations in terms of communication, we also didn't feel the need to engage so much in relation to consent, and in any case, there are exceptions to consent, best interest being an overriding consideration. The most contested element of the case was, of course, jurisdiction. We had the benefit of getting inputs from third-party interveners, a consortium of 3 experts, and then subsequently academics that were composed of 31 academics. They actually provided some inputs in terms of the question of jurisdiction, whether or not the committee can actually have jurisdiction to deal with this, but more importantly, whether or not the government of France can be considered to have jurisdiction in relation to these children that are in another territory. Of course, the issue of extraterritoriality was the one that we spent a significant amount of time. Now, if one looks at the drafting history of the Convention on the Rights of the Child, the Travaux Préparatoires, there was a conscious decision to move away from the criteria of territory or explicitly making jurisdiction being purely based on territory. In fact, in this respect, we are standing in a relatively better position than a couple of other treaty bodies. So if one looks at the Travaux Préparatoires, you get an indication that the drafters had intended to make sure that jurisdiction is not just only purely on territory, but there are other circumstances that might actually necessitate extraterritorial jurisdiction. From the inputs that were provided to the committee, there were a number of considerations that were brought to our attention. First of all, we were asked to look at the serious risk of irreparable harm that could happen to these children, the inability of the parents to protect their children, the territorial state's inability, in this case, Syria, or their unwillingness to assume jurisdiction in this particular case, the state party's ability to protect its nationals, in this case, France, whether or not they had the ability to protect these children and their parents, of course. And of course, the fact that the factors mentioned prevent an excessive extension of extraterritorial jurisdiction, because states usually would argue, in this case, France strongly argued that the extraterritorial jurisdiction context doesn't apply to them because they don't have control, because they don't want to deal with non-state actors, because they don't have the capacity, and so forth, so forth. Now, ultimately, the committee relied on a decision that it has made, and keeping in mind that the optional protocol only came into force in 2014, so our jurisprudence is not as expansive, for instance, as the Human Rights Committee on the Committee on the Elimination of Discrimination Against Women, or any of the other treaty bodies that have had the communications procedure before us. But we relied in one case. It's a decision called CE versus Belgium, where the committee considered that Belgium had jurisdiction to ensure that the rights of a child located in Morocco, in another country, who had been separated from a Belgian-Moroccan couple that had taken her under the kafala system, actually had jurisdiction. So that was the main case law that we relied on. But of course, there are a number of other things that were taken into account. Nationality was one element, but it was not the sole element. And it's important to emphasize that. We also looked at the capacity of the state in the sense that they knew where these children are, they were actually engaging. In fact, subsequently, information also came out that 35 French minors in total were actually repatriated. And in fact, France itself argued that they have the highest number than any other country in Western Europe as far as repatriation of minors was concerned. And that was given as an indication that the capacity existed. Now, so once jurisdiction was decided, we moved on to the merits. The merits were less complex. In fact, we looked at the circumstances that the children find themselves in. We looked at the conflicting arguments put forward by the parties as to whether states have an obligation to repatriate their nationals under public international law or international human rights law, and what falls within the scope of consular assistance that the state must provide to its national who are outside its territory. And as the committee, we considered the question to be resolved predominantly was whether, in the specific circumstance of the case, this case that was before us, whether the state party has taken all the necessary measures with due regard to the principle of the best interests of the child as a primary consideration to implement and ensure that the rights enshrined in the convention in respect of child victims who are under its jurisdiction. That was basically the main axis that our considerations revolved around. The question of capability, it was already evident from what the government has done as far as the 35 children that they were able to repatriate. In terms of the consent, as I've already mentioned, we already had established that the consent criteria was not going to be an overriding consideration because it can be overridden itself by the consideration of best interest. So we didn't have to argue much on that. Now, ultimately, the recommendations that were provided were that there was a violation of Article 6, given the circumstance that the children found themselves in, the deplorable circumstances that they were in the camps, and the fact that children were dying. The detention circumstances were considered to constitute a violation of Article 37(1), and that's in relation to inhuman and degrading treatment. And ultimately, we gave relatively extensive recommendations in relation to repatriation, in relation to the guarantee for non-repetition, the need to take positive measures and acting in good faith to effect the repatriation of the child victims and so forth, so forth. Let me use the last 30 seconds that I have by highlighting a few questions that I have seen being raised in relation to this case. One is nationality as a basis. Is that a concern? The decision does not say nationality alone is a sufficient basis for the protective obligation to arise. And that's an important point to emphasize. Now, is there a risk in relation to the capability approach? Because some have argued that, the capability approach might lead to a situation where states would be resting on their laurels and they wouldn't be taking measures. That remains to be seen, but we found that the capability approach played a very important role in our consideration here. I have heard questions whether or not it would have been necessary to do oral hearings, similar to the one that we did on the Sachi case on climate change. The committee didn't feel that, and usually oral hearings are the exception and not the rule. And I'm not terribly sure, at least as a member or as an individual even, I'm not terribly sure what would have been the added value if that was the case. And the final point that I need to mention is that is there a need for a detailed conversation about the implication of other aspects of international law? For instance, in this particular case, the Vienna Convention on Consular Relations? Absolutely. And I'm hoping that this panel is part of that process to have some of these reflections. Let me pause here, and I look forward to listening to my co-panelists and the subsequent interaction. Thank you. Over to you.
Thank you. Professor Neil Lang.
Thanks to everyone, and thank you for the opportunity to have this conversation. Let me also just note, as Ewan has done, that I come to this conversation both as an academic, but also as a special rapporteur on counterterrorism and human rights, where the regulation of a range of human rights issues in Northeast Syria have been squarely in the scope of the mandate's work in the last couple of years. And I have personally and my team have been enormously preoccupied with the situation in the camps, and in particular with the situation and the well-being of children. And I think it's important to say, maybe by way of general context for those new to this discussion on the streaming, that the camps Hol and Roj are notorious for multiple reasons. These camps were formerly refugee camps. They're pitched in the middle of an arid and what might be described as inhospitable desert. And they're the camps where women and children fleeing the fall of the caliphate were placed or sought refuge as the large-scale hostilities between ISIS and the global coalition to defeat them reached its high point. Now, I do want to sort of stress a question of nomenclature. Often the language of ISIS association or ISIS members is used to describe these women and children. And I would just underscore that that remains unproven, in the sense that many of these women we know were trafficked or groomed online before traveling to Syria and Iraq. And many of them were born there and then coerced into situations of relationship, including marriage and childbirth without choice. And the degree of affiliation that anyone has or has not with the terrorist group, the designated terrorist group, is unknown, because we've had no legal process to undertake any kind of determination on any individual who's been held in either of these camps. And it's in that context really obvious to say that the camps are a legal black hole, really defined by their lawlessness and their insecurity. Over 57 countries have third country nationals in the camps, and as Benjamin said, France is one of those countries, but it is not alone. And these countries run the gamut from Western democracies to states like China and central CIS states. Perhaps interestingly, the country with the highest percentage of persons who went to join the caliphate were the Maldives, those tiny little islands. So again, just to stress the range of countries, the range of nationalities here. As I think we all know, many countries simply refuse to take home their citizens and have engaged in what might be described as the ugly practice of citizen dumping on a non-state actor who's singularly ill-equipped to manage the complex needs of this population. And I think what the camps are, and in particular the situation of children, they're symbolic of this broader collective failure to address the humanitarian and security realities that have unfolded in Northeast Syria since the formal defeat of ISIL. The failure to, I think, deal with these broader security and human rights consequences of what is effectively a mass detention site, I think will have long-term consequences for the security of the region and beyond. A really clear example of this is in January, just a couple of months ago, there was a prison attack on Al Sinai prison in the southern part of the city of Al-Hasaka. That prison attack by ISIL showed both the kind of fragility of the prison's infrastructure, but also means that these prisons and sites of detention will remain a rallying cry and a security problem for the Syrian Democratic Forces and the coalition to defeat ISIS for as long as mass arbitrary detention continues. So the best estimate we have is there are about 70,000 women and children in these camps, and none, as I've said, have been subject to any legal process, zero. The conditions in the camps are unrelentingly dire. The consequences for children are devastating. The camps are makeshift and locked. They are made up of unstable tent-like structures which collapse in strong winds or flood in the rain. Sewage hygiene facilities are almost non-existent. And there's limited drinking water, which is often contaminated. Latrines are overflowing, mounds of garbage litter the ground, and illness, including viral infections, are rampant. So state the obvious in the context of the pandemic, this is not an ideal place for any child to be situated. Food, water, healthcare, and non-essential food supplied are provided by a highly under-resourced and really stretched humanitarian interface, small humanitarian groups and organizations. Again, it's important to say most of the population in the camp are under 10 years of age. None of them made the decision to be born into a detention facility. None of them chose their parents. And each child effectively is presumed to be affiliated to terrorism based on a set of presumptions about their presumed parentage, often with unidentified fathers. Few of these children have identity papers. Their ISIL birth certificates give them no recognized legal standing. And what's interesting, as Special Rapporteur engaging with many of these, well, all of these 57 countries, is they often engage in these formalistic reasons why neither passports nor exit can be provided to these children. But I think it's an interesting point to make that the states that are members of the global coalition against ISIL, there's an irony in the fact that they have a significant set of military resources present in the region and in Northeast Syria, including significant intelligence capacity gathering. So that's all deployed, but they're also then apparently structurally incapable of providing documents to children in safe passage home. And the irony is compounded by the fact when states refuse to take their nationals home, they're essentially, some of them, also helping to construct the prisons that are detaining their nationals. So a communication, the mandate issued last week to the states who are part of the coalition focused on following the money, which is paying for the prisons that are detaining children without due process, including the children of the countries paying for the construction, if that makes sense to all. So the daily realities in the camps are really, and the prisons are particularly harsh. And I want to particularly focus, as I have done in both my writing and as mandate holder, on the conditions of boys, the boy child. Because a number of these boy children are held not only in the camps, but actually they are in the prisons themselves, these loose array of prisons, including Al-Hasaka prison, which holds both adults and children, male children, perceived to have or being born from someone connected to ISIL. Those prisons, just the litany I just gave you on the camps are also true of the prison. Inadequate shelter, no bedding provision, unmanaged overcrowding, no access to sunlight. A lot of the boys in these facilities suffer from preventable childhood diseases, from scabies, skin conditions, and there's a large-scale problem with TB and also, obviously, COVID-19. Many of these boys in this prison facility suffer from unmet legal and medical attention, meaning they came into the prison with trauma and injury from having been physically harmed in either at the camps or before coming to the camps. But I want to underscore that after the prison attack in January, we have a significant number of boys who've been injured and harmed during the course of that attack, many of whom have unmet medical needs. What's really interesting is fundamentally how the boys end up in this prison. There's a de facto system of culling children from their mothers in the camp, boy children, when they reach the age of 10 or 11. So once they hit that arbitrary threshold where they're deemed to be suitable for removal from the camp, separation from their mothers and their siblings, they're then rehoused into this prison system. And it seems to me that this warehousing of adolescent boys from their mothers is an abhorrent practice, clearly incompatible with the dignity of the boy child, and is a form of gendered treatment that, if it were happening to girls, meaning if we were seeing large-scale separation of girls from their mother, we would be talking about sexual harm and the specific vulnerability of the girl. But often what happens in these kinds of armed conflict settings and their aftermath is the boy child, who's particularly vulnerable on multiple measures, is never seen as a gendered construction, and the harms that they're subject to really a product of their gender identity. So let me close out by talking about solutions. Well, the obvious solution and the only meaningful solution to the detention problem we have in Northeast Syria is to ensure the repatriation to countries of nationality. And we've actually already seen that. We have some progress in some countries. So I was in Uzbekistan and Central Asia in the autumn, and particularly assessing what's happening in Uzbekistan, who've engaged in large-scale repatriation, hundreds of women and children brought back from conflict zones, including Northeast Syria. And what we see there is a state making a political commitment and putting in place the adequate resources to ensure that they can engage in the kind of interdisciplinary, interagency, long-term work that's needed to ensure the reintegration of these children into their families, into their communities, and into the nation. We've seen a little bit of movement from European countries like Denmark and Germany, who moved from absolutist positions that they'll never take any children or mothers back to more recent moves to do so. And Germany, for example, did a relatively large-scale repatriation in the last 10 days. But other countries like Norway and Canada, two countries that theoretically say they're committed to the protection of the child in situations of armed conflict and are the kind of visible face of the children in armed conflict agenda at the UN, simply refuse to take their children back. So it would appear for these countries that this protection of child in armed conflict is narrowly focused on other children in other countries, but not your own children caught up in the maelstream and vicissitudes of conflict, and certainly not if your children are deemed to be arbitrarily said to be associated with terrorist groups by misfortune of birth. So repatriation is the gold standard, and we need to encourage these states to be bringing back their children. The reality, of course, is that we're seeing very little of that globally. The scale of the problem remains undiminished. But let's just have three kind of riffs on that and then I'll stop. Well, one is that even if we could convince all of these people to bring back, all of these countries to bring back their nationals, we would still have a large group that are essentially non-returnable. Here, the example I would give are the Uyghurs. We have a large group of Uyghur nationals, including Uyghur children, detained in the camp who can't be returned on the basis of non-refoulement. So we need a bespoke solution for that large population, whether it is in third countries or more problematically, but certainly would require enormous transformation to the living and structural conditions, is to maintain them in this region of Northeast Syria with effective human rights guarantees. The second thing we need is that there have been a large number of Syrians leaving the camps to return to parts of Syria and Northeast Syria from the camps in what are effectively de facto amnesties. We have very little understanding of those processes. We certainly don't know what are happening to children in those processes, and we have no oversight on protection of the child in particular. So that's a clearly a gap that needs to be remedied. The third thing we clearly need, the most basic thing we need, is a human rights compliant registration process that supports the best interest of the child, which would be put in place by a competent, likely UN entity who can work with countries to determine nationality, including by DNA testing when none of these children and sometimes their mothers have any papers. Let me pause and stop by saying that the solution here, it's sort of out of sight, out of mind, and Ukraine has displaced our focus and commitment to addressing any of the horrors that continue to unfold in Northeast Syria. But the reality is that this region remains profoundly unstable and a significant security threat. More than that, if we don't address the needs and rights of these children in the short term, we will certainly be dealing with the long-term consequences of that in terms of the kinds of conditions conducive to violence and extremism that holding people for a long, long time in these conditions produce. Thank you.
Thank you for that very bleak picture that you have painted so eloquently for us, and the rays of hope that repatriations can be pushed forward. Professor Modirzadeh.
Thank you very much, Professor Newman, and thank you to my colleagues who spoke before me. I'm afraid I will continue the bleak picture, but perhaps in a slightly different register. And let me just say in advance of my comments, particularly given that I'm speaking right after two world-renowned experts on these issues, that as we were saying before the meeting, I had not seen this case nor encountered the documents related to this case until Professor Newman's kind invitation. And so I'm reacting to that, but also in the context of the broader issues here. And second, that my hope is just to take a few minutes to situate this issue in a broader debate that I think has been taking place in far too small and insular of a part of the legal community, and that I hope we see reasons to expand not only more broadly within international law, but also on the political stage. So first, let me say that I really commend to those who do want to understand more about this issue. The special rapporteur's work on these issues is not only so important for the human rights issues and for the people involved, but also happens to be really incredibly written and incredibly intellectually, I think, rich. So first, just to recommend that. Also, the work of Azadeh Moaveni at the International Crisis Group has been really good on this issue. So I think what we've heard so far paints the picture of the horrific story of what is happening to these families that are in Northeast Syria. And of course, this is a story about many things, including the legacy of the invasion of Iraq, about jihadi violence and governance in Syria and Iraq, about the Syrian revolution, It is also a story, though, I think, and this is what I want to focus on, about how legal ideas and concepts and legal arguments and claims that we make can play a role in the lives of individual people, and in this case, children. So for those who I think sometimes feel that international law is so abstract that it's difficult to imagine what it means to people, I think this issue and this case illustrates why it matters how we think about the role of human rights law, international humanitarian law, which is what I will focus on, and counterterrorism norms. And that's what I'll say a few remarks about. So I was particularly drawn to one paragraph of the decision of the CRC committee, and that was the one summarizing the position of the French government on the question of international humanitarian law. And I recognize I'm on a panel with a major expert, so I will not, of course, represent French law, but as a matter of interpretation of international humanitarian law, the French position is, I think it's fair to say, striking, surprising, and problematic. And the reason is that it appears that the French position is effectively attempting to utilize international humanitarian law to wash their hands of responsibility for these children, for their fate, and for the underlying laws that will keep these children and their families more broadly in Syria or Iraq for potentially many years to come, if not indefinitely. So why do I say that? Why is that the case? So the French position in the CRC decision takes a few highly contested questions of international humanitarian law and renders them as though they are sort of very clear and obvious. And I wanted to highlight those as a way to better understand what's going on for many of the children. So not only French nationals, but other European nationals, as well as children from Middle Eastern and North African countries. The first is the idea that a non-state armed group has a right or authority to detain individuals in a non-international armed conflict. So that's a lot of uses of the word non, but the idea here being that the French government appears to be saying that the Syrian Defense Forces or others who might administer these camps are the party that is holding them in detention. And that means effectively that the detention is both non-arbitrary, but also that this is clearly governed by international humanitarian law. That is a highly debatable proposition, and that is an issue that is currently being contested in the field of international humanitarian law. We might have different opinions about that, but I want to emphasize that it is unstable in the law at the moment. The second is the idea that the detentions are non-arbitrary and not the responsibility of France to seek to remedy the condition of the children by repatriating them, because there are grounds for the detention under non-international armed conflict. So this is a highly contested proposition and certainly not a doctrinally settled one. We have had at least 20 years of robust debate between member states and in the field of international humanitarian law on this issue. Why does this matter? It matters because the claim seems to be that the women and children as family members of Daesh fighters are detainable under international humanitarian law. And that, I think the diplomatic way to say it is an innovative approach to understanding the grounds for detention in non-international armed conflict. Finally, the articulation of the French position, and of course I recognize that this is as expressed by the committee, I'm not reading the underlying original documents of the government. The final position that is quite striking is the idea that detention of the women and the children, so of the family members of the fighters, all falls within the category of imperative security threat under IHL. This is a very specific category of deprivation of liberty in international humanitarian law that applies to individuals who are found through an individual review process to pose an imperative threat to security and are regularly reviewed in order to ensure that their deprivation of liberty lasts only so long as that security threat continues to adhere. Certainly not the process that is being applied to these women and children in the camps. So why does it matter that there is this interpretation and this approach to international humanitarian law? Well, first, that I think this issue and the decision of the committee merits close scrutiny and attention of people who care about international humanitarian law. This issue has not only fallen below the attention of the world's public due to other events in the world, but it also has really not been a central concern for the field of humanitarian law, in part because the fate of these children often is seen as falling between the cracks of multiple fields of international law. So one, I hope events like this draw more attention to this issue and more attention to the legal interpretations of states such as France. I would be surprised if leading French government humanitarian lawyers had reviewed the position as it was articulated to the committee. Second, I think that what we see here and why it matters and why legal ideas matter is, I think, what is happening to these children can at least partly be blamed on the growing influence of counterterrorism norms and institutions on how we understand and apply international humanitarian law. I have a wonderful student, Audrey McKay, whose LLM paper is about this question. And she says, I think very rightly, that as international humanitarian law has stagnated on the issue of detention in non-international armed conflict, counterterrorism has exponentially grown and accelerated in this area. So what we see happening to many of the children and families that are allegedly affiliated with ISIS is that when international humanitarian law does not address and cover their detention, either because individual states do not wish to apply international humanitarian law, or, as I would argue in the case of these children, it simply is not clear that international humanitarian law would justify and allow for ongoing detention, it is very easy, and we see this happening in Syria and Iraq, to move these individuals into the category of counterterrorism, effectively to view their ongoing detention and their potential entry into the criminal justice system at some point in the future as being part of the global counterterrorism effort and part of an effort to comply with global and national counterterrorism norms. So I think this is a further reason for those who are concerned about the interpretation and application of international humanitarian law, who care about how IHL is applied, how it is interpreted, what it does in the world, to see this issue, these individuals who remain in detention in Northeast Syria, as well as those who have been transferred into criminal counterterrorism prosecution and imprisonment in Iraq, as fundamentally a challenge to international humanitarian law's ability and capacity to protect civilians and individuals deprived of their liberty in non-international armed conflicts. This is absolutely not the only situation in the world where we see this, but it is unusual in the sense that we have European governments apparently taking the position, as I believe France is taking in this case, that international humanitarian law authorizes a form of detention and a longevity of detention that is very, very difficult to substantiate through the doctrine as it exists today. I'll just close by saying, I remember being at a meeting of European security professionals, government legal advisors, and others at the height of ISIS's control over parts of Syria and Iraq, and when there was a real sense in continental Europe of almost a growing panic about what would happen with all of these foreign fighters who were traveling from Europe to the region and claiming that they wanted to build lives in the region. And I recall an expert who was advising European governments on their approach to the question specifically of children. I went back and looked at my conference notes because it had struck me so much at the time, saying that there had been child psychologists who had been consulted as part of developing the government's policy, and that any child over the age of 4 could not be brought back into civil society in Europe because their indoctrination would have effectively been completed by that time, and arguing that these children, effectively, there would need to be a solution that would either keep them in the region or would provide for some manner for them to be sort of kept apart from their societies were they to be repatriated. I think this is, in other words, an area where we have allowed for far too long an attitude that wishes for these children really to disappear, to be seen as acceptable, purportedly on the basis of the threat that the children pose. And yet, interestingly, as we see in this case and others, there is very little articulation of what exactly that threat is in 2022 and beyond. Thank you very much.
Thank you. Now, with a particularly French perspective, can we turn to Professor Vey?
Thank you so much, Jerry, for your kind invitation. Thank you for all the panelists for very interesting comments. So let me put it now in the French context. We have a president, you know him, Emmanuel Macron, who has just been re-elected for a second term. And before his first election, he had to deal as a member of the government and as a candidate to become president with the issue of the possible inclusion of the French constitution of deprivation of citizenship for French being involved in Daesh and condemned for crime. And the French president of that time, François Hollande, wanted to put in the constitution a special punishment, either for those who are dual national and then for those who were even only French. And finally, the French parliament didn't approve this provision. And Emmanuel Macron said, these people are part of ourselves. They are being raised in our community, national community. We should keep responsibility of them. And he was talking about criminals, about people who could have been condemned for killing, for being mass killers, like the one who acted in Charlie Hebdo, etc., etc. And now becoming president, he is acting towards children who have not committed any crime as implementing a kind of punishment, which is a kind of discretionary banishment, because they are French citizens. We'll come back on the protection of consular protection abroad, etc., etc. But they are French citizens, and they are innocent of any crime or any action that violated the law. And nevertheless, he doesn't want them to. He has decided for some of them not to repatriate them to their country of effective nationality, because you know that the term effective nationality is important in international. So now, how did the French court, justify and supported the French government in its decision? As you know, we have a dual jurisdiction in our country, and there is a jurisdiction which is specialized in all the cases that are raised against an official authority, and the Supreme Court of this branch is called the Conseil d'État, who in fact has a dual role of giving counsel to the government for some of its members and judging the government action when they are raised into the court. So the Conseil d'État invoked, after the case being raised in 2019, that these are acts of government, and there is a traditional jurisprudence that the judge doesn't decide on act of government. But in this particular decision, they went further than just saying it's an act of government. I will say it in French, and then I will translate, but Jerry knows French and many others of you knows. Une juridiction n'est pas compétente pour en connaître. And I would translate it, maybe a little with some exaggeration. No jurisdiction is competent to know to take this case. Why do they already wrote that? Because they are afraid of what will decide the European Court of Human Rights. I am taking very seriously the UN Commission on Human Rights opinion, but its decisions are not enforceable. The European Court of Human Rights decisions are enforceable. And there is the case pending, and in September, the 29th of September 2021, the Grand Chamber of the Court has studied and heard the case of women and children raised by their parents, and so the grandparents of the children. So what was shortly, what are the arguments on both sides? There is one argument which is raised by the claimant that the Article 3 of the Protocol number 4 of the European Convention is directly enforceable, and it says the Article 3, paragraph 2 says, no one shall be deprived of the right to enter the territory of the state which is a nation. To that conclusion or opinion, the French government claims that in international law, states have discretionary power to implement the consular protection and the freedom to appreciate the means involved to ensure or not to ensure this protection. To the question of the interpretation of this paragraph 2 of the Article 3 of the Protocol number 4, the French government says that it only applies if the person knock at the door of the border. I mean, is just there. It's not an obligation to ensure the transportation, the travel of the people of French abroad. So that is where we stand. Now let me, to conclude, make two remarks. First of all, the invocation of an action of the government, that the national government should not be submitted to the judge because it's an act of government, it's a political decision. And so, of course, it's great that cases are raised in the courts, and I hope the European court will impose the implementation of this protocol number 4. But if it's not implemented, I think there is only one way to make the government move. It is a political mobilization. It is a political mobilization. And after having, under the request of Jerry, read these cases, I'm now ready to use some political skill, I would say, after the decision of the court, if the court, we have to mobilize nationally and internationally. And if we want to mobilize internationally, I will here challenge Professor Neumann on how we could use the US jurisprudence on this case. I have been studying for other purposes, in fact, for the case of Edward Snowden, what we can do with the jurisprudence of the case, the slaughterhouse cases. The slaughterhouse cases, you know, it's the most it's the most horrible decision of the Supreme Court for many liberal colleagues who think that the court didn't obey the will of Congress to permit the civil rights to be implemented through the 14th Amendment, through the clause of privilege and immunities. But what I claim here, what I claim in an article I wrote, is that it's not nothing what they decided in the slaughterhouse cases. If you read it again, they decided about some absolute right of American citizens. So they mentioned the right who owe their existence to the federal government, its national character, its constitution, its law, and so the right to peaceably assemble, to petition for redress of grievance. Yet, and others, in this majority opinion, Justice Miller also deals with the privilege and immunities of the American citizen abroad. I don't know if you remember that, Jerry, you know everything, so you should remember. In a foreign land, and here I quote, another privilege of a citizen of the United States is to demand the care and protection of the federal government over his life, liberty, and property when on the high sea or within the jurisdiction of a foreign country. So I wonder if to support our action in France, US colleagues should not claim that under the US jurisprudence, this kid could be repatriated. I mean, you could force under this jurisprudence, the government, the federal government, to repatriate them if they were of American citizenship. Thank you.
Thank you, Professor Vey. I will take up that challenge for a moment simply to say the Privileges and Immunities Clause of the 14th Amendment, I agree, is not reduced to zero. However, the moment one tries in the current situation of the United States to seek revitalization of the Privileges and Immunities Clause, one notices that one is surrounded by people who would like to abolish the Due Process Clause of the 14th Amendment and restart US constitutional jurisprudence using the Privileges and Immunities Clause in its original intention, and no more. And so this is a particularly ticklish time in American legal history to be relying on that as a resource. There could be questions of justiciability that apply, like the issues that the Conseil d'Etat was referring to, also in the American jurisprudence. Even if in theory there is a right there, it might not be a judicially enforceable right. So before turning to the audience for questions, which I'll do in a moment, I do want to ask one question, which is we've mostly been talking about the children, and we've been talking about the children as children. Should we also be thinking about the situation of the mothers? And one twist on that would be to ask the question, does the decision of the Committee on the Rights of the Child stop with the repatriation of the children? Or is that simply the first step in the process, in which the next step is that the child says, for the sake of my own best interests, now that you're repatriating me, you have to repatriate my mother also. Is there anyone who'd like to speak to that?
Let me maybe start, Professor Newman. I think that in some ways the logic of the best interest test leads us directly to the mother. I think the reality is, and I would say just conceptually and practically, the minor child is invariably linked to the parent, which generally tends to be the mother. And in these circumstances, there are often no fathers in the picture. They've either been killed or they're imprisoned. We have had, I think, there are also some other difficult cases, which I think the committee is also sort of flagged, or it's prescient, which is where a best interest test might lead to a separation decision from the mother. And I can say there have been at least 2 cases that I have addressed as special rapporteur, in which a mother had taken children without the consent of the father to Syria and Iraq. And there was a domestic proceeding that had identified a breach of domestic law and the rights of the other parent in the context, which made us hold the position that separation was both permissible in that circumstances. The other set of circumstances around separation is around seeking consent from the mothers to bring their children home without them. And in fact, we've had a number of French cases involving these practices where the French government has asked mothers to consent to the release of their children. And I think that raises a number of other really problematic questions, which is the question of whether consent can be freely given in a situation of detention, which at least UN special procedure mechanisms have defined as meeting the threshold for torture, inhuman and degrading treatment under international law. So whether actually any parent could consent meaningfully to have their child returned home. And I think that's a really open question, and it'll be interesting what the committee might have to say about that in the context of the best interest test. And maybe just a footnote, which is to say, we're also not talking about the men. We have a large group of hundreds and hundreds of men detained in prisons. Again, in a situation of arbitrary detention under human rights law, because there's been no process and there's no end in sight. So we are potentially looking at a situation of indefinite, unending detention for thousands of men on the basis of their presumed or alleged affiliation with ISIL, with no legal process of determination in that regard.
Can I come in?
Please.
Thank you. As a precursor, there is a concern that the optional protocol on a communications procedure might be abused by parents for processes. There are some countries that at least I know, that are waiting on the sidelines, for instance, before they ratify, to see how jurisprudence is going to develop, because they're worried that it would be used for relocation cases, which is mostly guided by Hague Convention. They're worried that, aggrieved parties in a divorce proceeding might actually use the children's claim for a number of other intentions. So as a committee, we're actually very watchful of those situations, and we pay very close attention to those circumstances, but also keeping in mind that Article 5, even though the Convention on the Rights of the Child is about children and their rights. There are a couple of provisions which seem to suggest some derivative rights that parents might actually be able to enjoy because those children, their children are actually entitled to those. Article 5 is a good example. It says state parties shall respect the responsibilities, rights, and duties of parents, or where applicable, the members of their extended family, it says. So there may be instances where, because of children's rights, parents might also be able to enjoy some rights. So that Article 5 is an important provision to keep in mind. The other point that I need to mention is in the recommendation that we gave to the government of France, even though we don't talk about the mothers and the parents and so forth, the recommendations does not stop at repatriation, that hallelujah, repatriation is going to close this case. No. It talks about reintegration, it talks about resettlement, and so forth, so forth. So there may be arguments that can be built around the need to actually keep children and their mothers in some exceptional circumstances. But in this case, we didn't go deep into that. The third point that I want to mention, which Patrick also alluded to, the case that is pending before the European Court of Human Rights. One of the interesting things that actually happened in that case is that a number of countries, Sweden, Norway, Denmark, UK, and so forth, they asked for leave to join the case. And the reason why they did that, I would like to believe, is because they're not terribly worried about some of these children, because quite a number of these children, that are at least the ones that we dealt with in our case, they're actually very young. But I think they asked leave to join because whatever precedent might be made in relation to France in that particular case would have resonance for the other countries as well. So they want to avoid that situation where this thing is actually going to go beyond the children and might have significant implications in terms of bringing others that are adults back into Europe. Over to you.
Thank you. Let me turn to some of the questions from the audience. We have a question from Professor Jacqueline Baba, who asks, what criteria have states who have repatriated some of their nationals but not others used? Why can't non-discrimination principles be used to challenge this disparate treatment?
I think in the French case, they did not reveal their criteria. I would hope they would have revealed, because then you could go to court for if they were not implementing fair ones. But I don't think it was just used. They probably have criteria, but they are not public.
Professor Niolay?
I think we see some glimmers. There's no countries are issuing like formal statements usually, although in some of the responses by states to the communications to special procedure mandate holders on decisions to repatriate or not, we have seen some emerging criteria. So I've shared the web link for folks who want to dig into those national decision makings. What I have observed is a couple of things. For some countries, they will use humanitarian exceptionalism as the basis for bringing home particular individuals. A good example is Canada has repatriated one individual, a 5-year-old orphan child, and they use the fact of her lack of parentage and extreme concerns about her health as the basis. We've seen that in some French cases. For example, a woman who was seriously ill and her children were returned using those extreme health grounds, threat to the right to life, as the basis for bringing home. Countries who are doing mass repatriation like Uzbekistan and Kazakhstan are simply saying, we'll bring everyone back. And often the question is just kind of prioritizing through different returns who comes back and who doesn't. Professor Baba is right. There's a clear discrimination thread running through this. And one piece of that discrimination thread is that in a number of countries who have done repatriation, Denmark is a good example, those individuals in the camp who could be citizenship stripped were stripped in advance of the repatriation, meaning where an individual had another citizenship, the country stripped in order to ensure that they didn't have to have that person, frankly, if we were to be kind of cynically political. So we've seen countries trying to manage their, if you want, caseload of return by using citizenship as a basis for inclusion or not. And of course, a number of countries simply are not telling us why they're not returning, but they're citing, as Naz said, the overwhelming articulations are around security concerns or non-capacity, non-consular presence on the territory of Northeast Syria as a formal reason why they are unable to engage in the practicalities of return. Thanks.
Thank you. Professor Mesmo, did you want to add something?
Thank you. To just echo and supplement what the special rapporteur has said, one thing that we have seen across the board, that at least I've seen, is that there is an argument that says the political, legal, and ethical arguments are still going on. They're still being debated by parliamentarians and so forth. So that's one thing that, and the word on a case-by-case basis is something that is easily thrown around. So what does it actually mean? If you try to decipher, it comes to some of the points that the special rapporteur was saying. For instance, very young, we've seen cases. Orphans, we've seen cases. We've also seen cases where family initiatives, strong family initiatives supported by civil society organizations and so forth, that have actually brought about repatriation of individuals. So private family initiatives is one example. Now, some of those that have actually been able to repatriate, apart from those countries that were mentioned, for instance, Herzegovina or Albania and North Macedonia, they even adopted a national plan of action for mass repatriations. In some of those countries, it was disrupted as a result of COVID, but has been able to resume subsequent from COVID. Now, in relation to the European approach, the case-by-case approach has not been really helpful. You don't really know what the criteria is. For instance, the Netherlands repatriated 5 women with ties to ISIL along with their 11 children from Northeastern Syria because a court in the Netherlands decided to repatriate the 5 women and their children after they decided and said that it would terminate the proceedings that they had in front of them, and they could no longer be prosecuted for terrorist offenses. Now, this is not really a criteria that you can speak of, but it's an indication of the shortcomings of the system. Here in Switzerland, there has been a lot of pressure on the government of the Switzerland to actually bring. They have a very few number of individuals there, but the reaction from the government has been that the mothers have refused to be separated from their children, and they're sort of trying to use that as a prompt why they're not repatriating. So it's very haphazard, to say the least.
Thank you. Another question asks, based on the human rights approach to the situation of children living in Syrian or Iraqi camps, have any measures been taken to educate them and prevent them from joining terrorist groups? Have other effective measures been taken by the United Nations and other related countries to prevent the recurrence of these bitter experiences for children? I'd like to add onto that a little addition of my own, simply to say, and could it be said that we are focusing too much on the situation of children who have another foreign nationality? What about the situation of the children who have no other nationality and the conditions in the camps more generally? Professor Moderzadeh?
Yeah, thank you for raising that, Professor Newman, because I think it's often gets a bit lost in these debates, in part because for obvious reasons, the children of dual nationality have drawn media attention, perhaps not enough in their countries of nationality. I think, so my sense in response to this and also in response to Professor Baba is at least part of the story here and fully underscoring Professor Val's call for a political mobilization around this as really being the way to forge a solution, I think is that you have states that are manipulating what are effectively kind of choice of law regimes, if I can use that term loosely. So what I mean by that is it is entirely possible in the current thinking on counterterrorism and the law of war to say some group of people are going to be in law of war detention, potentially indefinitely, on the logic that law of war detention can continue as long as the war continues. It is possible to take another group of people and say those people are going to be subject to domestic criminal counterterrorism prosecution. So you see European governments looking at proposals to build detention facilities in Iraq and Syria for the purpose of taking these people, prosecuting them of loose terrorism charges in many cases, and then essentially the idea would be they would be in nice and humane detention facilities for extended periods of time. And then to take another group of people and say those people will be dealt with, will be repatriated or brought back into the lives of their countries, or gone through de-indoctrination processes and others. So the law here, the ability to move people to different categories of legal protection or lack thereof, is absolutely, in my view, facilitating how fractured this looks from the outside. How can there be so many European countries that have been military allies in this conflict taking such different approaches where two children living in the same camp, the same age, the same experience, might have unbelievably different lives ahead of them? And I think one thing that explains that is that we've allowed a situation to develop in the last 2 decades where individual states are able to make decisions about which body of law applies to individual people based on a rationale that is not transparent and is not subject to political contestation. And at least some part of this can be found, I think its roots can be found in the Guantanamo Bay detention facility. It isn't to make sort of silly or loose analogies, but to say there has been 2 decades of litigation for that detention facility that relies on a very similar logic, that we can pick and choose rules from different regimes and decide who gets put into which category based on security rationales that those of us in the public are not privy to.
Thank you, and thank you for smuggling in an answer to one of the other questions that was asked from the audience. Professor Neil Lane, I'd like to give you briefly the last word because we are going into overtime here and we'll need to bring the event to a close.
Thank you. I just wanted to underscore Naz's comment about forum and regime choice. The situation in Northeast Syria is not unconnected to 20 years of overreaching and unaccountable counterterrorism. And it is about the fact that each state gets to define terrorism on its own terms. This is precisely where we end up with European states taking vastly different approaches, but also as counterterrorism imperatives and norms displace human rights and humanitarian law norms. And I think this is one of the reasons why the decision of the committee is so important, is that it reestablishes the primacy of those norms in addressing the rights of those most affected by the downstream consequences of terrorism and counterterrorism. It is also the case, and I think I would underscore Naz's comment about the relationship between mass sites of detention, Guantanamo, Northeast Syria, Xinjiang, China. What all of these has in common is actually a sort of a permissible framework for mass detention in the international arena, something I think that we're long overdue a reckoning on in all of those multiple sites. Thanks.
Thank you. My deep thanks to the panel for all the light they have shed on this awful problem. And my thanks to the audience for joining us today to learn more and to contribute with your questions. Thank you.